Hello, I'm Chirag Karia KC, a barrister and King's Counsel at Quadrant Chambers, specializing in commercial, international trade, shipping, commodities, and energy law. I'm going to be talking briefly about the recent decision of the Court of Appeal in Sharp versus Viterra, in which I represented the successful buyer. The court in that case had to decide how, open quotes, the actual or estimated value of the goods on the date of default, close quotes, in subclause C of the GAFTA default clause was to be construed and applied in the case of a non-acceptance of goods by the buyer. The commercial background. The commercial background to this case and that provision is that approximately 80% of the world's grain trade is conducted using GAFTA standard form contracts. And the GAFTA default clause appears in 64 out of the 78 GAFTA contracts presently in use. Therefore, it's no underestimate to say that a ruling on the proper construction and effect of the GAFTA default clause is a matter of considerable importance to the international grain trade. Sharp involved the sale of Canadian lentils and yellow peas CNF free out Mundra, India from Vancouver. The buyer failed to pay cash on delivery as required, but the parties agreed that the buyer could discharge, customs clear, and store the goods in a warehouse subject to the seller's control. The parties later agreed that the buyer could also pay by installments. After the goods had been customs cleared by the buyer, in December 2017, the Indian government imposed import tariffs of 50% on the peas and 30.9% on the lentils. The buyer nevertheless failed to pay for the goods. The seller terminated the contract and applied for damages under the default clause. The tribunal found that the date of default was the 2nd of February 2018, which crucially was after the buyer had customs cleared the goods and after the Indian government had imposed import tariffs on goods of the same type. As a result of the imposition of those tariffs, the tribunal found that the value of the customs cleared goods left in the seller's hands had undoubtedly increased. Nevertheless, the appeal board did not use that value when assessing the seller's loss, but instead constructed a hypothetical value of those goods by determining the price at which the similar goods could be purchased in Vancouver on the date of default, and then adding to that the cost of freight. The seller was awarded $5.067 million, but the buyer said that the seller had lost no more than about $1.4 million. The buyer appealed to the commercial court, and Mr. Justice Jacobs granted permission on the general public importance basis, but crucially also indicated he would have been prepared to do so on the obviously wrong basis. The commercial court, however, upheld the decision of the appeal board in a judgment by Mrs. Justice Cockrell. In the Court of Appeal, the Court of Appeal purported to apply dicta from the Supreme Court's decision in Bungie and Midera and held that the goods were not to be valued as is, where is, which is what the buyer had argued, but, and I quote here, by reference to a notional substitute contract entered into on the default date on identical terms save as the price. Applied to the facts of Sharp, the court held that the correct valuation required the positing of a contract of sale entered into on the date of default of customs cleared goods ex-warehouse on installment payment terms. The crucial provision in that ruling is customs cleared goods, because it was the fact that the goods had been customs cleared that had now enhanced their value. The takeaway from this decision is that the actual or estimated value of the goods on the date of default under subclause C of the GAFTA default clause is not their value as is, where is, which I respectfully submit is what the parties who drafted the clause would have intended, but instead is the price that they would have been sold at under, quotes, a notional substitute contract entered into on the default date on identical terms save as to price. In my opinion, it remains to be seen how this theoretical, and indeed some may say metaphysical, approach to valuation plays out in practice. The Court of Appeal refused the seller permission to appeal to the Supreme Court, but the seller has renewed that application directly to the Supreme Court. So watch this space. There may be some developments. Thank you for listening.